Fight for Justice is brought to you by the Kia Store of Anniston and Rainbow City.
Good evening, everybody. Welcome to another edition of Fight for Justice. We've got a special show for you tonight. Some good friends of mine from Montgomery are up, and we're going to talk about the criminal process, expungement, some high-profile cases that they've been involved with, and briefly talk about the Tony Stewart incident that occurred this past weekend. I'd like to introduce Bill and Ben Espy.
Good morning.
Good morning.
I appreciate you guys coming up. Ben, if you could tell us a little bit about your firm in Montgomery.
Yeah, sure. We were fortunate to just have celebrated our 50th anniversary. The firm was founded in 1964 by Oakley Melton Jr., who was our senior partner, who unfortunately for us passed away about a year ago. He was a good friend and a mentor. My father joined the firm in the early 70s, and then ultimately Jim Williams, our third name partner, joined the firm in the 1980s, and Melton, Espy, and Williams PC was born. We have, even before that, done just about everything, wills, probate work, but over the course of the last 10, 15 years, we've really focused more on trial work. We do a good bit of medical malpractice defense type work, and really over the last 4 or 5 years since Bill's been with us, we've really begun to focus on criminal law and in large part white collar criminal law and high profile political corruption and that sort of thing.
All right. Bill, if you don't mind, why don't you tell us a little bit just about the criminal process in general?
Sure. I guess just to get down to I'm going to get down to the quick basics of how criminal law. There's basically kind of two different categories of crimes you can be charged with. The first one being your misdemeanor charge, which deals with such as trespass or minors in possession of alcohol. In those cases, you deal with the most you can be sentenced with is up to a year in jail. Those cases, actually, let's take a trespass case. If somebody believes that you trespass on their land, they merely go up to the district court or the clerk's office, file a complaint on you, and off that, you are arrested. People are actually shocked by that you can be just arrested on somebody going up there and filing a charge on you. You are arrested, you have to bond out, and you can either plead guilty, cut a deal, or go to trial. There is no grand jury process really in the misdemeanor the procedure, and when you go to trial, it's in district court or municipal court, and there is no jury. So the judge is the trier of fact, and when you appeal that case, you can, though, if you lose, appeal that case, and it goes to circuit court where you have a jury. In a felony case, there's a wide range. Of charges. You can from theft of over $500 all the way up to murder. Also, a long range of sentences, such as you get 1 year and a day in jail, or you get life in prison, and Alabama still has the death penalty. So in the felonies, there are exceptions, but most cases, somebody has a complaint with a local PD, local police department, they investigate your case and they take it to a grand jury. Put witnesses before a grand jury, evidence before a grand jury. The grand jury decides if you should be indicted or not. If they indict you, that's when you're formally charged with the case. They arrest you. You have to bond out. Once again, you can, plead guilty or try to cut a plea agreement. That case is in circuit court where you will have a jury, and that's basically kind of your breakdown of your misdemeanors versus felonies and the procedure in the criminal process.
That's interesting because we don't do a lot of criminal law. Mostly what we do is civil, personal injury, business disputes, and stuff like that. So a lot of this stuff is I'm learning as well just tonight with the audience. But Ben, if you could just briefly, or take as much time as you want, tell us about the importance of the grand jury.
Well, like Bill said, every felony begins with a trip to the grand jury. Grand jury is made up of normal citizens who are impounded a lot like a regular jury. They come in, and it's a little different than what you're used to in a trial. The attorneys who would represent the accused, what will ultimately be the defendant, aren't allowed to participate. The defendant does not testify. It is a very one-sided operation. The government attorney, whether it be federal government, local district attorney, they get to subpoena who they want, when they want. They can subpoena what documents they want. And so it's, as you hear sometimes they say, a grand jury would indict a ham sandwich, and that's the truth. If they want an indictment, they'll get one. And it's a one-sided proceeding. The grand jury never gets to hear the defendant's side of things. That happens, unfortunately, after the defendant's been indicted and there's already been a trial going on. So what I would say to your viewers, which I think I'd want to know if I were them, the most important thing is if you get a grand jury subpoena, always go and see an attorney. There are lots and lots of people who have been in trouble for thinking, I haven't done anything wrong, I can go down there and talk to them, I can explain to them what happened, and have found themselves in a whole mess of trouble. So what I would say is if you get a grand jury subpoena, make sure you go see an attorney who can help you assess whether you've got a problem, whether you should go, who they should talk to, and keep those sorts of things in mind. Don't ever go down there by yourself. Don't ever take that chance.
I've got from our other conversations before we went on the air, I was pretty surprised about the discovery rules and how they differ between civil and criminal cases. Why don't you explain to the audience a little bit about that, Bill?
They differ greatly, and I think people, mainly when we get a client who comes in who doesn't know much about the criminal process, I think that they are really shocked that the limited amount of discovery that you get in a criminal case, in a civil case, as you know, Freeman, you get to take people's depositions, and in this case, you're talking about money. Can I get this money? You get to take people's depositions, you get a wide range of discovery. But when it comes to criminal cases and talking about somebody's freedom, you hardly get any discovery. And I think that's what's most shocking when we talk to our clients. My brother just talked about the grand jury. The grand jury is secret, and nobody gets to know what happens in there except for the prosecutors. And that's why my brother said it's very one-sided. When the client comes in and says, I know this person went to the grand jury, I want to know what they said. And you say to them, well, you can't get that. They don't give it to you. They're shocked. You don't get all these witnesses that go before the grand jury. You get none of that testimony. And in fact, the only discovery you get is what your own client says and what is called exculpatory evidence, which is decided upon by the prosecutor. So the prosecutor gets to decide what is exculpatory, which means what would be favorable evidence for your client. And well, they don't think anything's favorable for your client, so you don't really get anything. So it's a very limited discovery, and so you really got to get out there and dig, get witnesses, and do the discovery phase yourself in the criminal case.
So it sounds like basically you have to do your own investigation, just like the cops or the detectives or the prosecutors actually do in that case as well.
Absolutely. I mean, that's one of the reasons why, not just if you get a grand jury subpoena, but if you get contacted by law enforcement, FBI, Securities Commission has investigators, IRS has investigators, every administrative body has an investigator. If you get a phone call from an investigator, you get a subpoena to appear at a grand jury, you need to go and see a lawyer immediately and let that lawyer talk with you, determine what problems you may or may not have, talk with the people who want to investigate you, determine whether or not talking to them is in your best interest. But primarily what you want is for the attorney to begin his investigation as early as possible. By the time you learn you have a problem, typically the government, whoever's investigating you, is way, way ahead of you. And so what you want to do is get the lawyer involved and let them investigate
let me stop
as
you real
quickly
quick.
as possible.
We're going to a break. We'll come back after this and pick up where we left off. Welcome back, everybody. We're going to pick up where we left off, and then we're going to get into some of the more high-profile cases that the Espys have been involved with, including the bingo trials. We're going to talk about some other cases that they haven't been involved with, just to get their thoughts on stuff like the Tony Stewart incident and maybe even touch on the Trayvon Martin incident as well. Ben, if you don't mind, cut you off at the end of the last segment. Why don't you try to pick up and tell the audience a little bit more about the investigation that a defense attorney has to do?
Absolutely. Like I was saying, it is important to get an attorney involved early and often. like I was saying, by the time you get involved, it may have been months, it could even have been years that you've been investigated, that they've been going out, talking to people, collecting documents. For example, Bill and I have a case now where we have 1 million documents have been provided to us by the Securities and Exchange Commission. They've been looking at something for several years. All of a sudden, boom, we get hit with 1 million documents and they want to set our guy for trial in a couple of months. That puts you at a disadvantage. So the sooner you get somebody involved, the sooner they understand what your problems are, the quicker they can determine what kind of help you need and what kind of people you need involved with you. It's important for people to understand, because a lot of people don't understand this, that you don't have to speak to investigating officers when they come and speak to you if you don't want to, just like you don't have to speak to me if I call you. When I have a case, a criminal case, and somebody hires me, I start trying to track down the witnesses, talk with the witnesses, and they're certainly free to tell me, hey, Mr. Espy, I don't want to be involved, I don't want to speak to you, and I may encourage them to talk to me and encourage them to be fair with my client, but certainly once they've said no, I understand they have that right. A lot of times the investigating officers who show up, they don't tell people that they can say no. They insinuate that it's in their best interest to talk to them. They indicate if you don't, it could be a problem. So a lot of times people are more willing to talk to law enforcement because really law enforcement can do stuff to you I can't. So that puts me at a disadvantage. The law enforcement can speak to you, I can't. So it makes my investigation that much more problematic. So that's just a handful of things that make investigating criminal matters difficult for the defense attorney, and why you should always get somebody involved in day one as quick as humanly possible.
I also want to, there's been a new law passed in Alabama this year dealing with expungement. And while we don't do a lot of criminal work, I certainly get calls all the time asking if someone's arrest or someone's conviction can be expunged. And until this year, it wasn't possible, I don't believe, in Alabama. Right. And so I think we have a graphic to throw up on the screen. Just a brief introductory information about expungement, and I'm going to have Bill and Ben talk briefly about that as well.
Yeah, sure. This is a brand new law, as you can see from the graphic. It was introduced by Roger Bedford in the last legislative session. Became effective July 17th, 2014. Number 2, number 3 are probably the most important part of the expungement law if you're considering asking somebody about it. Number 1, if you have been convicted of the crime, you cannot get an expungement. It only applies to things which you have been charged, not things which you have been convicted. So, for example, you're in college, you have a little bit too much to drink at a football game, you get picked up for a public intox. They take you down to see the judge. He says, I don't want to cause this kid too much problem. You do 100 hours of community service and we'll dismiss it. Great, you do it. He dismisses it. You're not convicted, but you've got this charge on your record. So that's the kind of thing the expungement law is designed to take care of. And then the third graphic there, you'll see it applies to misdemeanors and certain non-violent felonies. Misdemeanor, Bill's explained that earlier. Non-violent felony is very important. That is, there's a statute that defines what violent felonies are. You have kidnapping, murder, manslaughter, rape, things like that. If you have been charged with what's considered a violent felony, you cannot get expungement. It has to be a non-violent felony. If you think you fall into either one of those categories, you got a misdemeanor, non-violent felony, you weren't convicted, but it's on your record, I encourage you to go see a lawyer and ask them about it. The expungement law will erase that. What the law says very clearly is if you apply for it, if you can get it, if the judge grants it to you, it's as if it never occurred. And that's a really, really good thing for what I'd call youthful indiscretion. Like I said with the Alabama football thing, drinking too much, wandering around, you're 25 years old, you did something stupid, now you're 45 years old, and every time you go to a job, you got to put it down and explain to somebody what you did. And if it comes down to you and another guy, and you're the same, but you got this thing and he ain't got it, then he may get the job and you may not. But now you can go and get that expunged. It's a $300 fee. The judge can have a hearing, not have a hearing, depends on if it's opposed or not. Typically not going to be opposed, but that's a great new law. And if you have something in your past you want to get rid of and you think you may qualify, you should certainly look into that and contact an attorney.
Now that was informative.
He's got it down.
We're gonna spend the rest of the show talking about stuff that's a little more entertaining, including the bingo trials. We're going to spend the rest of this segment and probably most of the last segment talking about that, and get their opinions as well on Tony Stewart. Can he be charged? If he can be charged, what could be charged with? The difficulty maybe in getting a conviction if he is to be charged. So I want to start off just by asking you guys about the bingo trials, the Melton McGregor trials. I know you guys were the lawyers for Mr. McGregor, at least 2 of them. So if you can, tell us a little bit, tell our audience a little bit about those cases.
Sure. A lot of people think that the McGregor trial, what some people call Bingo 1 and Bingo 2, were about casino gambling and whether that was legal or not, or how that affected that. It really didn't have anything to do with that. It had to do with a bill called Espy 380 that was working its way through the legislature in 2010 that would finally clarify whether or not electronic bingo was legal statewide. And to be clear, so everybody understands this, electronic bingo is absolutely legal in Macon County. It's legal in Greene County. They have constitutional amendments that have been passed by those people. It is legal there, regardless of what the Attorney General or anybody else says. But with regards to SB 380 in 2010, they were going to clarify whether or not it was legal statewide. They were going to set up a gaming commission, places you could have the various parlors, generate hundreds of millions of dollars for the state of Alabama. In conjunction with that, a number of Republican representatives, who are all, fortunately for us, ex-representatives now, Senator Scott Beeson and others, went to the FBI, got wires, and then spent a considerable amount of time trying to entrap people like our client into giving them bribes. Obviously, we were lucky enough to represent somebody like Mr. McGregor who wouldn't do that. So at the end of the day, we were very successful in getting everybody acquitted, but that's the basics of what that case was about.
All right. I don't think we have enough time to fully get into this right now. We only have about 30 seconds, but just with what we have left, and we'll start off fresh in the last segment about this. Bill, I know a lot of what you did for the bingo trials or the McGregor trials, we're actually listening to the hours upon hours upon hours of tapes where people had been taped. And so when we come back from the break, I'd like you to talk to the audience about that process. How many hours of tapes did you have, and what you found on those tapes. So thank you, and we'll see you in 2 minutes. Welcome back, everybody. When we left off, we were asking Bill about his job. One of his jobs dealing with the bingo trials was to listen to the hours of tape that the FBI had taken. So Bill, why don't you start off and tell us a little bit about that?
Yeah, when we got into this case, our father was the lead attorney, and we got lucky to be involved in the case. Ben cross-examined a bunch of FBI agents, and he's probably on FBI's most wanted list after that. But I got to listen to the tapes, and they said they held a big press conference, and they wrote an indictment, and they said that the tapes is what they were going to prove their case. So I wanted to get into it, and I wanted to get into them and listen to them. I listened to over 1,000 hours of tape. I think I'm the only person on this planet, including the FBI agents, that actually listened to the tapes. And I was shocked when I listened to the tapes, especially how they crafted the indictment. They took that indictment. I think it was 90 pages, and they would take a snippet of a wiretap and put it on there and take it completely out of context. And it was really shocking. The tapes actually proved that our clients were innocent, and I think if you talk to the jurors in both our cases, they were waiting the whole trial to see if a wiretap had Melton McGregor or any of these defendants bribing anybody, and all it had was the government's main witnesses, Ronnie Gilley and Jared Massey, bribing people. And at the end of the day, they're the only people that went to jail, and all our clients went scot-free. And I think it's because of the wiretaps why they got off.
There was a lot of message board fodder and rumor in general that that Mr. McGregor had bought Cam Newton.
Right.
I take it that was not on those tapes.
As an avid Alabama fan, I'm going to tell you, I got on those tapes to see if it was true myself. We got on there and we listened to those tapes. Unfortunately for you Alabama fans, there is no mention of Cam Newton or Auburn on any of those tapes. But I think Melton. What did Melton say, Ben? He said
I think Melton would tell you that he would have paid a whole lot more for Cam Newton than the numbers they were throwing around.
Melton said it was $250,000.
He's kidding, of course, but that's what Melton would tell you, I think.
He said $250,000 would have been a steal for Cam Newton, I think. But no, there's no mention of Cam Newton on those tapes. But some of those people that wired up and turned on. I mean, the Republicans all wired up and had wires and went into their own Republican caucus meetings and tape their own, friends that people thought they were their friends, they said some shocking things. And I think Bobby Siegel said it best in the trial that if you are going to say that with a wiretap on you and knowing that people are going to hear it, God help you for what you're saying when you're not wiretapped. So the wiretaps, we turned to our advantage, and we won with those tapes.
There were a lot of people that were rumored, I've heard the tapes, and that's kind of how those rumors got started. Why don't you tell the audience actually who gets to listen to those tapes in cases like that?
Those tapes were highly confidential tapes. The only people that got to listen to those tapes were lawyers for the defense. There were, I think, 9 different defendants in the case. Lawyers for the defense got to listen to tapes. The FBI got to listen to tapes. They probably should have listened to all of them, and I bet next time they will. And the prosecutors got to listen to the tapes, but they were all destroyed when the trial was over. There's no way anybody's on some message board throwing around that they listened to the tape. It's just not true.
Well, what is the status of bingo or gambling in the state right now with the legislature or county to county, statewide? Where do we stand with that right now?
It's way more complicated than it should be. I think easily it could be decided by a vote of the people. Milton McGregor wants a vote of the people. I think the people want a vote. I don't think Luther Strange or some other people want a vote, which I don't really understand. But it's a little complicated. What you have is you start out in Alabama with the premise that by the Constitution, gambling is illegal. But you can have amendments to that. And I think about 13 or so counties in Alabama have an amendment to that to where bingo is legal in that county. So Macon County has a bingo amendment that makes bingo legal in Macon County. And they ran bingo there, electronic bingo, for 7 years without anybody, saying anything to them until the raids started happening. So right now, in fact, we have a trial coming up in the end of this year about the forfeiture, about the raid that Luther Strange did at Macon County and shut down Macon County, Richland. They raided, took the machines, and took some money, and we have a trial at the end of this year. We say that Macon County has an amendment that they can legally play bingo, and that what they try to say is they're slot machines, and it's just a joke. And what we're trying to fight for, and Milton McGregor's all fought for, is to get Victorland back open and get Macon County having 2,000 jobs back and paying taxes, because Indian bingo is regulated by federal law. They do not even pay taxes. And they get to be running and gunning electronic bingo, but the people who'd be paying taxes in Alabama don't get to play it. It doesn't make any sense to anybody that I talk to.
I also want to talk a little bit about and just ask you guys your opinion on what happened recently with Tony Stewart. Did you guys see the incident?
Yeah, I saw the videotape of it. I think me and Bill were talking about it on the drive up here.
What do you think? Is it possible? I know you guys, this happened in New York, I think, so the laws could be a little different there. But if something like that happened here, do you think that could possibly bring charges?
Well, I mean, we're pretty in a great racing area with Talladega being here, so I'm not going to say anything bad about Tony Stewart, I don't think. But I don't think you really could charge him with anything. The guy got out of the car and ran onto the track, I think, from the videotape, but you can't see it in the videotape what Tony Stewart is actually doing. I think if you were going to charge him with something, if vehicular homicide is a felony, I don't think you could really charge reckless driving of his vehicle. Well, he's on a racetrack to race. I think there's a criminally negligent homicide, which is a misdemeanor, like I talked about earlier, that you could charge him with. But I don't think you could find any juror or any judge to find Tony Stewart guilty of any crime while he's out there racing on a racetrack.
It's certainly hard to tell from the tape. There's rumors that there are other tapes, but it's certainly hard to tell what his intent was, if it was to scare him or if he just flat out didn't see him.
Right.
I know you guys have the great pleasure of working with your father, like I do with mine. I take it you guys enjoy that as much as I do.
We do, absolutely. It's a great experience to work with a great mentor, and we enjoy it. Every day's an adventure, as you know, when your old man's around. But we've enjoyed it. We've learned a lot, and wouldn't be where we are without his mentoring, his tutelage.
Well, I've obviously known Joe Espy for a while and gotten to take a few trips with him, and I really respect him, and I know he's a great lawyer, and I know you guys enjoy it a lot, and hopefully someday, soon, maybe in the next few months, you guys can come up and bring him with you.
Sure.
I want to thank the audience and thank the guests for
Thank
being
you.
here, and I hope you guys enjoyed it, and we look forward to seeing you next week.